The sources of American law. American law comes from a number of places. We can think of these as being arranged in a hierarchy. The Constitution is the supreme source of law, and it cannot be overturned by any of the other sources of law in the system. Next in line are statutes. Statutes must conform to the constraints of the Constitution, but cannot be overturned by administrative regulations or the common law created by the courts. Administrative law is a step below this, with a narrower authority for rulemaking. The courts round out the bottom of the hierarchy, as they have a very limited area of authority for autonomous policymaking. The Constitution is the source of law that we're probably the most familiar with. The most important part about the Constitution for our purposes is that it creates a framework for the rest of the laws of the land. First, it sets out the procedural rules through which federal laws can be made. This process is familiar to you from your 101 course. The Constitution creates a Congress and tells us how to staff it. It stipulates that both houses of Congress must pass laws and that they must send the laws to the President for his assent. If the President vetoes the law, the Congress may override the veto by a 2/3 majority in both houses of Congress. But the Constitution also lays out significant substantive limits on the lawmaking powers of government. First, the Constitution gives a list of enumerated congressional powers and allows Congress the authority to pass only those laws necessary and proper to achieving the goals laid out in Article 1. Additional substantive limits were added to the Constitution in the form of amendments. For example, if a law follows all of the proper procedures, it is still not valid law if it violates the freedom of speech. And the Constitution is at the top of the hierarchy because it is very hard to change. Laws of Congress cannot overturn the provisions of the Constitution. The Constitution can be amended by one of the onerous processes laid out in Article 5. The only other way to really change the Constitution is not to change its words, but to change how we interpret the existing words. Consider the Eighth Amendment's prohibition on cruel and unusual punishment. Perhaps cutting off a convict's ears might have been considered acceptable at the time the Eighth Amendment was ratified. But if we as society rethink the meaning of the phrase cruel and unusual punishment, such that it now precludes ear amputation, we might not allow the government to mete out this particular punishment anymore. The words of the Constitution haven't changed, but the interpretation has. The Constitution is the supreme law of the land, despite its diminutive size. It only has 4,440 words. It is the shortest constitution of any major national government, but most Americans only know 3 of the words. One last note about constitutions. The American states all have their own constitutions. State constitutions lay out the procedural mechanisms by which state laws are created. While they are relatively similar to one another, there are some differences. For example, Nebraska's constitution is the only one that currently prescribes a unicameral state legislature. Some constitutions provide additional rights above and beyond those protected by the federal constitution. For example, the constitutions of 6 states have been interpreted to require equal marriage rights to same-sex couples. In contrast, 30 state constitutions expressly deny equal marriage rights to same-sex couples. The second source of law on the hierarchy is statutes. Statutes are passed through the legislative framework established by the Constitution. So, they are laws enacted by lawmakers. Federal statutes are enacted by Congress, and state laws are enacted by the state legislatures. States also give authority to their localities to pass ordinances pertaining to certain facets of local governance. If you turn your television to Channel 2, you'll likely find local government in action. But lawmakers must abide by the limits placed on them by their place in the hierarchy. So, a city council will not be able to overturn a state statute, just as a state statute will not be able to overturn a properly conceived federal statute. And a federal statute cannot overturn a provision of the federal Constitution. Lawmakers must also abide by the substantive restrictions. Since the Bill of Rights has been largely incorporated to the states, none of these lawmakers may pass laws that abridge the fundamental substantive limits contained there, such as the freedom of speech or now the right to bear arms. While the Constitution is relatively brief, we have all sorts of laws in this country. The federal statutes alone take up more than 200,000 pages. If you'd like to see them all, you can check them out at the government printing office and find out what's in there. The next source of law is administrative law. Administrative law deals with the power of the various parts of the executive branch to implement the laws passed by the legislature. So administrative law is basically rules made by the bureaucracy. Typically, Congress will delegate particular authority to the bureaucracy in order to clarify congressional statutes and to turn them into precise rules that citizens and organizations will be able to follow. Their authority is typically derived from Congress, although Congress cannot delegate its core legislative duties to the bureaucracy. Another source of administrative law is the president. The president can issue executive orders. Most of the time, we can think of these executive orders like other kinds of administrative law, where the president gets his authority from an act of Congress. In these instances, the executive order is the president's way of clarifying how he and his administration will be implementing the law. But sometimes executive orders are more like statutes. This happens when the president is acting not on the authority of Congress, but on the powers vested in him by Article 2 of the Constitution. Lowest in our hierarchy is the courts. The courts have very little space for autonomous lawmaking. Our courts are bound by the issues in the cases that come to them, and they are low on the hierarchy because their primary source of power is the interpretation of the other sources of law. In other words, they get to clarify the meaning of statutes in the context of an actual set of case facts. Of course, this might make us wonder why we should care about the courts at all. Well, although their power to make law is limited, their power to interpret the law is very expansive. Indeed, the courts are the ones who interpret the Constitution. The courts are the only ones who can fundamentally change the meaning of the Constitution without going through the incredibly difficult amendment process. In this way, you might say that judges are bound by the Constitution, but the Constitution is whatever the judges say it is. The sources of American law. American law comes from a number of places. We can think of these as being arranged in a hierarchy. The Constitution is the supreme source of law, and it cannot be overturned by any of the other sources of law in the system. Next in line are statutes. Statutes must conform to the constraints of the Constitution, but cannot be overturned by administrative regulations or the